So the final part of our Module 1 lecture series is the classification of crimes, culpability, and the physical and mental act, and causation. From our first part, we spoke about the significance and the differences between what was a criminal offense and a civil tort. If you remember, civil offenses could result in incarceration, meaning jail time or prison time, or even ultimately the death penalty. Or a civil offense, or what's known as a tort, results in monetary damages. Criminal responsibility has to be proven against the defendant to proceed through the criminal justice process. A crime is an act or an omission forbidden by law, which means it's in some criminal code or established by some statute. It has to be against the public interest or morality, and that the act requires punishment, which is an important aspect of an act being considered a crime. In terms of crime, the victim is often a person, but the crime is against the community as a whole, and the community is the legal victim in criminal cases. The social harm requires retribution or punishment through a criminal process. The prosecution represents the community, not the specific victim. Even when a victim initiates a case by a complaint. And if you just look at case names, this kind of reflects this concept. You may have a case titled State versus Robinson or United States versus Billings. This represents that the victim is not a particular person, but the state in the State versus Robinson, or the United States in the case of United States versus Billings. There's morality and a requirement for punishment. And this means that these mean different things at different times to different persons. Under civil responsibility, again, we have what's known, the violation is known as a tort. This is a wrongful act that results in some type of injury, whether it be physical, mental, monetary, a breach of contract, or a breach of trust. And this entitles the injured to compensation. This is an act against an individual or group of individuals. It's not the community as a whole, so it's not considered a crime. The remedy involves action by a wronged individual or a group against an individual or group that's violated a civil law. And again, it's for monetary damages. There's no possibility of punishment. So in a civil action, there's no loss of life or loss of liberty. But a single act can be considered a crime and a tort. For example, negligent homicide. In our example, the driver of the vehicle is determined to be negligent in the killing of another driver. The driver can be convicted and punished as part of a criminal case, as well as responsible in a civil case or a lawsuit to cover medical costs, funeral costs, or other damages incurred by the other driver. There's a moral responsibility. There's an act that is morally bad may result in criminal and civil cases against the offender. For example, murder has criminal sanctions. There's civil action for wrongful death, and there's moral condemnation by the community. Not all immoral acts are civil or criminal acts. This is based on the American philosophy of individual freedom. Criminal law prohibits extreme conduct, not thoughts or low moral character. Actions or inactions must be specific to be considered a crime. A felony is a serious crime punishable by more than a year of imprisonment, served in prison, or punishable by death. For example, crimes like homicide, rape, robbery, possession and distribution of narcotics, arson are all considered felonies. Felonies don't have to be committed against a specific person or be violent in nature. Crimes like drug crimes or white collar crimes are considered felonies as well. Felonies are divided into categories or degrees to reflect the seriousness of the offense, specific victims, aggravating circumstances, or the potential severity of sentencing. So you may hear the term first-degree murder, second-degree murder, manslaughter, negligent homicide, etc. These are all categories and degrees of the crime of homicide. A misdemeanor is less serious than a felony and is punishable by a fine, some type of penalty, or maybe even incarceration, which can be served in a local or county jail, an alternative program, or even a treatment center. And this term of incarceration is for less than a year. These are crimes like disorderly conduct, shoplifting, theft, hit and run, first or second offense driving while intoxicated, and other offenses. There are crimes that are considered what's known as wobblers. These are crimes that may be prosecuted as a felony or misdemeanor, and there's considerations given to prior offenses of the accused, seriousness of the offense, the number and sometimes age of the victims, and the age of the accused. You have petty offenses, which are insignificant crimes of very minor misconduct. These are intended to be a protection of the public welfare. And these crimes often result in the payment of a fine or some type of penalty like community service, suspension of a driver's license, etc. These are considered violations or infractions rather than crimes. And the Model Penal Code actually classifies these as non-criminal. These are things like traffic offenses, things like public drunkenness or jaywalking. The elements of criminal liability are considered in terms of culpability. These are the actions in the state of mind required to hold a person criminally responsible. Criminal liability has five elements that have to be proven. The actus reus, which is the physical act of committing the crime. The mens rea, which is the mental state, the thought, the planning, the preparation to commit the crime. When those two come together, the unity of actus reus and mens rea, the causation and the resulting social harm. Actus reus is the act or physical element of the crime. For example, one person shoots another. There may be actus reus by omission or failure to act. For example, a person fails to provide reasonable care to the infirm or to their child. This differs from the desire, the wish, or the hope about a crime. Until the act is committed, there is no crime. Actus reus must be a voluntary action. The accused must possess sufficient free will to exercise choice and be responsible for the act. Regret simply doesn't take away a person's responsibility. But there are limited circumstances when a person has no control or criminal responsibility, like their medical condition, mental infirmity, their age, or other circumstances. So in terms of actus reus, you have to consider thoughts versus actions. A person cannot be punished for their thoughts, only when these thoughts are acted on. In terms of actus reus, there can be an omission by acts, which means there's failing to act, which can constitute criminal liability in two situations. The crime's definition designates omission as punishable. For example, failure to file your income taxes, or failure to provide care to children to ensure they are not injured or their well-being is not threatened. For example, not feeding a child leading to their starvation. A duty to act may evolve from the nature of the relationship, such as the parent-child relationship, doctor-patient relationship, or this relationship may be imposed by law. For example, drivers involved in accidents, or by a contract, If there's no relationship, there's no duty to act. Words as acts as part of actus reus. Under certain circumstances, words can constitute actus reus. These words constitute a threat or cause future physical harm. The where and the how and sometimes who means that falsely yelling fire in a crowded movie theater, threaten to harm the president, the governor, or elected official can constitute the actus reus. Actus reus can exist in terms of words when it creates some conflict with the First Amendment. A balance has to be struck between prosecuting individuals' right to speech and the potential that the harm could be inflicted. Possession as an act under actus reus means that physical possession knowingly of something prohibited constitutes a criminal act. The item or substance will likely be used in commission of a crime, or the possession of the act is used as a deterrent. For example, possession of illegal drugs, bomb-making materials, burglars' tools, or other certain weapons constitute actus reus. Mens rea is the mental state. It's the mental state of a person at the time the act of constituting the commission of a crime. This differs from motive. The motive is the emotion prompting someone to act, or the why of someone's actions. A malice afterthought is a mens rea requirement for murder and contains 4 elements: specific intent to kill, intent to inflict serious bodily injury, wanton disregard for human life, and commission of a dangerous felony. Specific intent can be any one of the following examples: intent to do an act for the purpose of doing an act in the future, intent to do an act to achieve some further consequences beyond the conduct or result that constitutes the actus reus of the offense, intent to do an act with the awareness of statutory attendant circumstance. General intent is the intent only to do the actus reus of the crime, with none of the states of mind and specific intent. Transferred intent occurs when the consequences of the accused actions is not what the actor actually intended. For example, when a person intends to harm one person but mistakenly harms another. Strict liability means that a person can be convicted of a crime without having the mental state or intention to commit the crime. For example, the mistake of age in a sex case, or in the case of liquor or tobacco sales. The Model Penal Code classifies mens rea in 4 classes: acting with purpose, which is with respect to result or conduct; voluntary wish to act in a certain way; or with respect to attendant circumstances, means the awareness of conditions that make a crime possible. The second class is acting knowingly. Knowingly causes a result. A person knows or is in certain conduct will cause a result. Knowingly with respect to conduct in attendant circumstances. The person knows criminal conduct exists, or the circumstances make a legal act criminal. The third class is acting recklessly. The person voluntarily ignores a substantial or unjustified risk that a certain circumstance exists or will result from their actions. The last classification is acting negligently. The person should be aware that a substantial and unjustified risk exists or will exist or will result from the negligent conduct. Another element of a crime is concurrence, that the crime requires concurrence of actus reus and mens rea. A person can only be convicted if he or she performed a voluntary act accompanied by a mental state that caused the prohibited act. There are 2 components of concurrence. The mental state must have been present at the same time the act was committed or omitted. This is the temporal requirement of concurrence. The concurrence of the two states must be motivational. This is what's known as the motivational requirement. In our module, you learn to define the types of law in the American criminal justice system. You learn to identify the components and purposes within the American criminal justice system and describe the process of determining if legal action violates a constitutional prohibition. You learn to contrast criminal, tort, and moral responsibility. And then finally, to differentiate between the various types of criminal offenses.